All right, good evening, ladies and gentlemen. My name is Matt Green. I am president of our local Federalist chapter, Federalist Society chapter. That's right. There will be no election. The ayes have it. This is the Brevard Hand Alex Howard chapter. Tonight we are excited to host Clark Neily of the Institute of Justice. He will be speaking tonight on judicial engagement. For those of you who don't know and who have not been to any of our events, the Federalist Society is a nonpartisan, conservative, and libertarian organization dedicated to freedom, federalism, and judicial restraint. We seek to educate the community about current legal events and through our programs and events like tonight about how limited constitutional government is the best prescription for liberty. It's founded on the principles that the state exists to preserve freedom, that separation of powers is essential to the Constitution, in that it is emphatically the duty and province of the judiciary to say what the law is, not what it should be. A little bit about Clark. He joined the Institute for Justice as a senior attorney in 2000. He litigates liberty, property rights, and school choice. He also does First Amendment cases and other constitutional cases in both state and federal court, so he is a constitutional litigator. He's helped create the Institute's Center for Judicial Engagement, which was designed to challenge the unconstitutional expansion of government by articulating a principled vision of judicial review, educating the public about the importance of a properly engaged judiciary, not activist, properly engaged judiciary, and advocating the Constitution as a charter of liberty and a bulwark against the illegitimate assumption of power by the government. Clark has written several books. Actually, he's written a book about judicial engagement, which he'll be speaking on tonight. I've emailed everyone about it. It's Terms of Engagement, How Our Courts Should Enforce the Constitution's Promise of a Limited Government. Really is a fascinating read. And for those of you who thought that the Privileges and Immunities Clause of the 14th Amendment is a dead letter, you can certainly take solace in the fact that Clark doesn't believe that. And there are a lot of actually people that, including some justices, I believe Justice Thomas, who still thinks it's the proper remedy for local and state government usurpation of our liberties. But the book is a great read. I would encourage everyone to take a look at it. You can even visit the Institute for Justice website. They have several videos about it. And you can go to Cato as well. They have a great video of Clark debating, is it Ed Whelan? Ed Whelan. It's very interesting. I think I may have emailed the link to that to most of you as well. In his private capacity, Clark actually served as co-counsel for Dick Heller as one of the plaintiffs in the seminal Second Amendment case that held that the right to keep and bear arms is an individual right, unconnected with militia service. It was the first time that the Second Amendment actually protects an individual right for self-defense, to possess a gun for self-defense. Before joining the Institute, Clark spent 4 years as a litigator at the Dallas firm Thompson & Knight, where he worked on a wide variety of matters, including professional malpractice, First Amendment and media law, complex commercial cases, and intellectual property litigation. He's received both his undergraduate and his law degrees from the University of Texas, where he was also chief articles editor of the Texas Law Review. And he also clerked for Judge Royce Lambert from the U.S. District Court for the District of Columbia. Briefly, I'm not going to steal any his thunder, but Clark is espoused of... I'll keep it somewhat brief. Clark has really taken on a position, and our position with the Federalist Society is of judicial restraint. And that has been a conservative mainstay, judicial restraint and judicial deference to the legislature. And that has been pretty much a bulwark or a belief many conservatives have held for a long time. That all changed for many in the Obamacare decision, where the Chief Justice held a penalty to be a tax. And many, including Clark, have argued that was an act of judicial activism, or the court bent over too far to save a statute that was clearly unconstitutional. And he's been arguing that a long time. A lot of people at Cato, including Randy Barnett. But there's still some conservatives that argue that that is in fact that should be the role of judges is to defer to the legislature. And there are two principal positions that the conservative and I guess the libertarians take, and they're really emphasized really well in two short videos I'm going to show you. Every year, the National Federalist Society has a meeting. It was just at the Mayflower Hotel up in D.C. when this happened, and it was a judge of the Fourth Circuit Court of Appeals, J. Harvey Wilkinson, who represents the conservative judicial deference argument. He makes that pitch, and then Randy Barnett, who's a professor of law at Georgetown University, makes the argument that Clark makes that the courts need to be not necessarily activist, but they need to be more engaged and hold the government to task when they assert certain reasons in justification of laws that encroach on our liberties. So I'm going to briefly show you these two videos and clips that kind of sum up both sides of this argument. This was I think it was the 6th annual Rosencrantz debate, and it was resolved, courts are too deferential to the legislature, and this was up at the Mayflower Hotel this past November. This is Judge Harvey Wilkinson, proponent of judicial deference.
You can get a stagecoach and you can ride me straight out of Dodge for what I'm about to say. You can boo me and you can hiss me, okay? It's a freebie. But the Chief Justice's vote in the Affordable Care Act case was courageous and it was correct. What we should do is leave it to the political process to point out the flaws in statutes, to expose the flaws in statutes. And the political process in pointing out the flaws in legislative enactment seems to be doing its job just fine.
And after the Hobby Lobby oral arguments today, it certainly seems like it may go that way. But the next speaker, this is going to be Randy Barnett, Professor Randy Barnett at Georgetown Law School. He's actually a former litigator too. He used to be a prosecutor at one time, I believe.
In Cook County.
Yeah, so I'm in Cook County. So here's his take on that and his response to Judge Wilkinson's judicial deference theory.
Found it was unconstitutional. So this is something that is within the competence of judges to do, and it's something that is their duty to do. That is, the old standard was that if a law was irrational, arbitrary, or discriminatory, then it was an unconstitutional exercise of an enumerated power, and therefore would be improper under the necessary and proper clause, or it was an unconstitutional exercise of the police power because the police power did not extend to passing laws that were irrational, arbitrary, or discriminatory. Finally, let me talk about the problem of double deference, because in practice, deference to legislatures sounds okay, and in principle, I myself don't have a problem with what is sometimes referred to as deferring to the policy judgments of legislatures. I think that's entirely okay. Legislatures do engage in policy. The judges generally should not engage. They should not engage in policy. Strike the generally. They should not engage in policy. That's not their job. Their job is to assess constitutionality. It's not to choose wise policy over bad policies. That's not their job. But in practice, what deference to the legislature then is switched to mean is deference to the legislative assessment that a law is within its powers. That is, deference to the legislature's judgment that a law is constitutional. Now, that's not something I think judges should defer to. They are an equal branch of the federal government, and they're entitled to their own opinion about whether a law is constitutional, and there's no reason why the legislature should get two bites at the apple and have exclusive control over the scope of its own powers. That would be to not respect the rights retained by the people. But what really happens in this town, everywhere, when this happens, and this is, I would defy anyone to say that this isn't what happens, and that is when a judge, when the federal courts or when the Supreme Court defers to Congress and says, no, we defer to you and your judgment of constitutionality, what happens when you go across the street and on the Hill and ask a legislator whether what they're doing is constitutional? What answer do you get? The answer that you get every single time is, what I'm doing is constitutional because the courts will uphold me. What we're doing is constitutional because the courts will uphold me. Well, if the doctrine is that the courts will uphold you because they are deferring to your judgment of constitutionality, and then you say a measure is constitutional because the courts will uphold me, then this is what's going on, and this is what's being lost in the process. You have each side pointing the finger at the other side. That's not my job to say whether it's constitutional, that's their job, and each side does that. This completely drops from the process, and as a result of the doctrine of double deference, we end up having lost very important clauses of the written Constitution that is meant to secure the liberties of the people, the sovereign people, each and every one of us. Thank you.
All right, so both make very compelling arguments. And this is kind of where we are. So at this time, I will yield the remainder of my time to the Honorable Mr. Clark Neily to make the case for an engaged judiciary. Please join me in welcoming him.
Thank you, Matt. If it's all right with you, I'm going to move this podium. As a libertarian constitutional litigator, I have a sort of a phobia of podiums. Very little good happens when I'm standing behind one, especially in a room full of judges. So thank you for the warm introduction. It's really an honor to be here with so many interesting and distinguished people, and I want to sort of front load the talk by saying I do have some very strong things to say about the way the judiciary is enforcing, or more precisely, failing to enforce the Constitution these days. I know there are a lot of judges in the room. I want to assure you, I am perfectly aware that lower court judges are bound to apply precedent, and I don't quibble with that. I don't argue with that. So to the extent that the U.S. Supreme Court has given lower court judges their marching orders on matters of U.S. constitutional law, to the extent that lower court judges have received marching orders from state Supreme Court judges on questions of state constitutional law, I'm not faulting anybody in the room for basically taking their marching orders. I'm very aware that some judges sometimes have to make decisions they disagree with because it's a matter of precedent. So let me preface it by saying that, because I'm going to say some pretty tough things about the current state of constitutional adjudication, which, in a word, is a disgrace. I've been litigating constitutional cases for 14 years. I revere this document, the U.S. Constitution, as I know everybody else in the room does, and I'm here to tell you that the genius of the U.S. Constitution, and we all know this, is limited government. It is the greatest, in my opinion, greatest secular document ever written. There is one reason, and one reason only, why the U.S. Constitution is the longest running constitution of any major constitution in the world, and that is because the framers got it right. And what they got right is that the state exists to protect the rights of individuals. Individuals do not exist to advance the interests of the state. We have an individual-centric government in this country. It's not a government-centric constitutional system. That's my view anyway. The other thing the framers got right is that we are a rule of law nation. I was a Russian major as an undergrad. I have been in the Soviet Union. I know what it is like to be in a country that is not a rule of law country, and in a word, it is terrifying because nothing is predictable. There are no limits on what the government can do if you run afoul of them, and nothing is secure, not property, not individual liberty, nothing. It is my judgment that we are on the verge of not being a rule of law nation anymore, for reasons I'll get into in a moment. And unfortunately is my conclusion, after thinking about it a lot, after writing this book, which was a product not only of a lot of thought and reflection, but debating the topic of judicial review, judicial engagement. I'll explain what that means in a moment, at law schools all over the country. Basically, the conclusion I came to is this. We have a constitution of limited government, but when you look around and you see that our government is anything but limited, I must lay the blame for that primarily at the feet of the judiciary. And I'm sorry to have to say that, but in my opinion, this is a fundamental truth that we all have to understand and appreciate. The other branches of government really don't take the Constitution very seriously. Certainly individuals within the legislature do. Some individuals within the executive do. But as branches, they don't. The idea that the U.S. Congress thinks for a moment about the constitutionality of the laws that it enacts is a folly. It is a fantasy. It does not happen. There is only one branch that is both charged with and will plausibly act to enforce constitutional limits on government power. That is the judiciary. If that branch doesn't discharge that duty, it will not be discharged. I absolutely agree with Randy Barnett on this point. You can choose one of two things. You can choose reflexive judicial restraint. Nobody, by the way, argues with just plain, straight old judicial restraint in the sense of don't go looking for trouble, don't make policy, don't involve yourself in things that aren't truly matters of constitutional import. But what I'm talking about is really reflexive judicial restraint, of the kind, unfortunately, that I believe J. Harvey Wilkinson has talked himself into. I know Judge Wilkinson. I think the world of him. I've read his book, Cosmic Constitutional Theory. I talk about it somewhat in the book. He is a wonderful, courtly gentleman, but I think he is absolutely wrong in where he's gotten to. He is one of the leading proponents of this kind of reflexive judicial restraint. And I just want to share with you one place that it takes you. For those of you who don't know, about 3 or 4 months after the team that I was on won the Heller gun case, Judge Wilkinson published an article in the Virginia Law Review in which he compared the Supreme Court's decision in Heller to Roe v. Wade, and essentially argued that striking down a gun control law was essentially the constitutional equivalent of striking down an abortion law, an anti-abortion law. And that's just wrong. And I think you have to have made some really serious mistakes to get yourself to a point where that's what you think. And the mistakes, in my opinion, that Judge Wilkinson has made is a very simple and basic conceptual mistake. And that is that he has talked himself into the idea that if there is any argument that can be made for the constitutionality of a law or something else the government is doing, then a judge is obligated to embrace, again, any sort of conceivable argument. So, for example, as most of you know, the Second Amendment has this militia clause. I'm not going to get into what I think it means. Everybody probably has their own opinion. We can get into it in the Q&A. But certainly basically with the Second Amendment, like with any other constitutional provision, if you want to figure out some way to render it inoperable, you can do it. And believe me, the Chief Justice can definitely do it. He's one of the most persuasive human beings who's ever been born in the last 2 or 3 generations, Chief Justice Roberts. And the idea that Chief Justice Roberts could look at any law or any provision of the Constitution and not find some ambiguity, some wiggle room, is ridiculous. He will always find. It's what he's been trained to do, and he's probably the smartest guy in the room. Whatever room he's in, he will always find ambiguity. He will always find wiggle room if that's the job, if that's what he perceives his job to be. And unfortunately, the Supreme Court's doctrine these days is this. What they say to all judges is, if you can find any way, in most areas of constitutional law, if you can find any way to rule in favor of the government, do it. And what I'm here to talk about today is how wrong I think that is, how I have perceived that in operation as a litigator working in the trenches on property rights cases, economic liberty cases, free speech cases for the last 14 years. And I'm here to tell you, it's ugly. And I'm unsparing in the book. I'll be very upfront with you. I'm unsparing in the book. I do not believe that there are really 3 levels of review. That's what law students are taught, that there are 3 standards of review that courts apply in constitutional cases. Strict scrutiny for rights that are really important, intermediate scrutiny for rights that are only kind of important, and then rational basis review for rights that aren't very important at all. That may be true in some doctrinal sense, but it's largely irrelevant. The only thing that matters, from my perspective as a working constitutional litigator, there are only 2 forms of judging in constitutional cases, real and fake. The Obamacare decision was an example of fake judging. I was one of the lawyers in the Kelo v. City of New London case, in which the Supreme Court held that the government may take home belonging to one private individual, give that land to a private property developer just to build Yuppieville. Maybe the tax base will go up, or maybe they'll create some jobs. That's fake judging. That is not in any way an attempt to understand and apply the Constitution consistent with the vision of the framers. After all, the Fifth Amendment and the public use provision, the Fifth Amendment was written precisely to stop that from happening. That is exactly the scenario scenario that the framers envisioned and why they put the public use provision in the Fifth Amendment. And so when the Supreme Court rubber stamped the government's authority to take land from one private owner and give it to another, the government was doing precisely what the Constitution was written to prevent. And so when the Supreme Court said yes to that, it rendered the Fifth Amendment, or at least that provision of the Fifth Amendment, utterly meaningless. Just as I would say Chief Justice Roberts' opinion in the Obamacare case, I wouldn't say rendered because that was done some time ago, but affirmed that the doctrine of federalism and the 10th Amendment are essentially meaningless now. The courts are not making any real, genuine effort to enforce the doctrine of federalism. I want to pause on that and emphasize this. There is no more important protection of liberty in the U.S. Constitution than the doctrine of federalism. In fact, we almost didn't have a U.S. Constitution because the biggest gripe that Americans had with the Constitution was their fear that it would create a federal government that would turn around and tyrannize Americans just the same way that the British government had, that we'd spent 8 years and countless cost and treasure and blood throwing off. And so that was the big debate. And it was only when the Federalists were able to convince the people of this country that the federal government they proposed to create with the U.S. Constitution would be one of few and defined powers that the Constitution was ratified. And that was the basis of the constitutional bargain. That was the promise that was made to the people of this country, that the federal government would be one of few and defined powers. And you can read them in about 30 seconds. I mean, depending how fast you read, but they take up about a page and a half of this tiny little document, Article 1, Section 8. Coining money, punishing pirates, standing army, navy. It's not much more than that. And that promise was kept up until the 1930s and the New Deal, when, depending on which historian you read, either the Supreme Court was intimidated by the president into changing its interpretation of the Constitution or just decided to go along with the program. But one way or the other, the Supreme Court decided that it would not be in the business of enforcing the doctrine of federalism, which is to say the Constitution's plan of delegated and enumerated federal powers, that it would not be in the business of enforcing that in any meaningful way. And as many of you, I'm sure, know, the seminal case was a 1942 decision called Wickard v. Filburn, in which a farmer from Ohio was growing wheat on his own property to feed his livestock. He didn't buy wheat on the interstate wheat market, and he didn't sell any wheat on the interstate wheat market. And so when the federal government came to him and said, we are going to punish you because you're growing more wheat than some federal commissar up in D.C. allotted to him personally, he said, you don't have any constitutional basis to tell me how much wheat I can grow because I'm not participating in the interstate wheat market and there's no other constitutional hook. That should have been a deal-killing argument. But the Supreme Court invented something called the aggregation doctrine, where the Supreme Court essentially said, okay, your personal conduct may not affect the interstate wheat market, but if every farmer in the country did what you do, which is grow your own wheat and withhold your purchasing power from the interstate wheat market, that aggregated would have an effect. Well, at that point, there's nothing. There's absolutely nothing that you can't shove into that doctrine. Think about something as prosaic as brushing your teeth at night. If you do it a lot, then we need more toothpaste and toothbrushes, and that's interstate commerce. If you don't do it much, well, then we need more dentists, and that's interstate commerce. And that's the kind of, I would say, intellectual gamesmanship that, for me, is the hallmark of fake judging. And the Supreme Court has been engaged in demonstrably fake judging in many areas for, I would say, at least the past 75 or 80 years. Randy Barnett actually argued the Gonzalez v. Raich case. This was a case involving medicinal marijuana, and whatever you feel like about the drug war, whatever your personal feelings are, the issue in this case was if one person grows a plant in their backyard, it happened to be cannabis, but it's a plant, and then gives some of that to a neighbor, doesn't cross state lines, and there's no sale, so it's not commercial, can the federal government regulate that under its power to regulate interstate commerce? So you grow a plant, you give it to somebody next door, and the federal government steps in and says, we're putting you both in jail because it's illegal to possess marijuana. And your argument is, no interstate commerce. This stuff never crossed a state line, and I didn't sell it. And the U.S. Supreme Court, 6-3, in a 2005 decision called Gonzalez v. Raich, said, yes, the federal government has the power to criminalize that conduct using its power of interstate commerce. That's fake judging. That is not in any way an attempt to get the Constitution right, to respect the vision of the founders, or to deliver on the promise of a federal government of few and defined powers. And I think it is perfectly appropriate for us to lay that at the feet of the U.S. Supreme Court and say that you have violated the deal. You have violated the promise that was made to the people of this country who were promised a federal government of limited powers. Turning to the part of the Constitution that I deal with mostly, we don't do a lot of federalism cases at the Institute for Justice, but I do a lot of individual liberty cases, primarily property rights and economic liberty. I want to start with property rights. I mentioned the Kelo case a moment ago. I had a very interesting experience. I went out, Kelo came down in June of 2005, and I was out on the road by August debating that decision with law professors all over the country. It so happened that my first debate was at my alma mater, the University of Texas, which is down in Austin. And it also so happened that the day I was there to debate a property professor on the Kelo decision, two partners from my old law firm up in Dallas were down on campus recruiting. And I went up to say hello, and one of them told me, you know, I just had an experience that you might find interesting, and so feel free to make of this what you will. He was an intellectual property partner, and he had just come back from China, where he was in China 1 month before Kelo came down. He didn't know anything about Kelo. It wasn't on his radar screen. But he happened to be in China a month before the decision came down. And he was there to open a computer chip factory in mainland China. And his host said, would you like to go and see where the factory is going to be? And he said, yeah, that'd be great. They take him out in the countryside. They come up over a hill, and they look down, and there's a village. And the host points at the village and says, that's where the factory is going to be. And the lawyer from Texas says, but there's a village there. We can't have a factory there. And the guy says, his host says, oh, the government will make them leave. And without hesitating, he said, oh, you can't do that in my country. And 1 month later, he found out by a 5-4 decision of the U.S. Supreme Court that he was wrong, that the U.S. Supreme Court considers property rights in this country to be no more secure than they are in communist China. And we ought to pause and think about that as lawyers, those of us who are lawyers. There's a huge public backlash against Kelo, as there should have been, because it was a disgraceful and un-American decision. But as lawyers, we should stop and think about what the Supreme Court did right there and said that property rights in the United States of America are no more secure than in communist China? I mean, you have really, really taken an intellectual wrong turn when you've gotten down into that kind of a cul-de-sac. And as Justice Thomas said in his Kelo dissent, something has gone seriously awry with this court's interpretation of the Constitution. That is exactly right. Now, I'm not going to name any names, but I will tell you that at least one very, very influential judge in this country, conservative, believes that the Kelo decision was correct. In fact, I will name one name because he's already on record, Judge Alex Kozinski, who up until this point was one of the leading libertarian judges in the country on the Ninth Circuit. Kozinski gave an interview with Reason magazine in which he said he thought Kelo was correct. The other judge I have in mind is above him in pay grade. That is reflexive deference. That is getting it wrong and holding on to your wrong interpretation of the Constitution and holding on to your wrong understanding of the role of judges long past the point where you should know that you're wrong. I want to give you another example. This one's much closer, near and dear to my heart because I litigated this case, and this was my personal experience with fake judging. A term that I'm going to explain in just a moment, and I'll finish with that explanation. I litigate mostly economic liberty cases. I represent people who are trying to earn a living in the occupation of their choice, free from unreasonable government interference. The Supreme Court has held consistently for over a century that each and every one of us have that right, the right to earn a living in the occupation of our choice. Now, the Supreme Court has withdrawn any meaningful protection for that right, but they've never actually abrogated it, or at least they've never said, okay, we were wrong. They're actually, in America, there is no right to earn a living. So in theory, and according to, not just theory, but in doctrine, according to the U.S. Supreme Court, as a matter of U.S. Supreme Court precedent, we all have a right to earn a living. I represented a woman in Louisiana named Sandy Meadows, who was a widow from Mississippi working in Baton Rouge, a high school dropout, and when her husband died, she had to support herself. She had only one means of support. There was only one thing that she was good at, and that was making flower arrangements. And in Louisiana is the only state in the country where you can't sell floral arrangements without permission from the government. You actually have to be a licensed florist to sell flower arrangements. I mean, on the one hand, you say to yourself, that's nuts. But on the other hand, if you have even a little bit of economic sophistication, you understand perfectly well that it's not nuts whatsoever. It's nuts if you think of the legislature as being reliably public-spirited, I grant you that. But if you have even a smidgen of economic sophistication, if you didn't just fall off a turnip truck, you understand very well where that law came from. And so Sandy Meadows was working as a florist in the underground floral economy because she took that test 5 times. Oh, I should tell you, by the way, they have a, got to hand it to Louisiana. They have this nice little rigged exam that you can take if you want to try to break into the market, but as I say, it is rigged. So you actually, they've changed it since then. We kind of shamed them into changing their exam, which is really saying something in Louisiana. But at the time we challenged the law in 2003, to get a license to be a florist in Louisiana, you actually had to go and take a practical exam where you would do floral arrangements and then you walk your work up to a table where there wouldn't be some theoretically disinterested bureaucrat. They would actually bring in working florists from the industry to judge your work and decide if you're good enough to compete with them. And it will surprise no one, I'm sure, that they usually said no. We actually went and got the data going back 10 years, and we determined that the pass rate in the Louisiana florist exam over the past 10 years was 36%. For point of comparison, the pass rate in the Louisiana bar exam was 61.5%. It was about twice as hard to be a florist in Louisiana as it was to be a lawyer. Now, as I said, Sandy Meadows was bravely working in the black market floral industry, but somehow she popped up on the Louisiana Horticulture Commission's radar screen, aka the Floral Police. And they actually sent some people over to the Albertsons grocery store where she was running the floral department and said, she doesn't have a license, and you got to hire a licensed florist or we're going to shut you down. Problem was they didn't need 2 florists, they only needed 1. And so they hired a state licensed florist and let Sandy go. And as I said, all she was good at was being a florist. And she took that exam 5 times, got flunked every time, not because she wasn't good enough, the whole thing was rigged. So she lost her job because the state said you have to have a license to engage in this perfectly harmless occupation. We were challenging that law in court, and for those who don't know, the Supreme Court, I'll take just 30 seconds here to sort of explain to you how the Supreme Court approaches individual liberty. The Supreme Court basically divides your rights into 2 categories that it calls fundamental and non-fundamental. So you have fundamental rights and non-fundamental rights. As a working constitutional litigator, I think a much more accurate way to describe that is important rights and unimportant rights. Meaningful rights and meaningless rights. And according to the US Supreme Court, there are very few truly meaningful rights, in other words, rights that you can go into court and have a legitimate chance of vindicating. Most of the rights that you have are meaningless rights, including your right to earn a living. Supreme Court considers that to be a non-fundamental right, that is to say meaningless, and we know it's meaningless because the standard of review that applies is the rational basis test, which I'm going to tell you right now is a fraud. The rational basis test is an intellectual and jurisprudential fraud that was invented in the progressive era to enable the courts to rubber stamp whatever the government is doing. I'm going to just lay that down, and we can certainly discuss that in the Q&A, but I litigate rational basis cases for a living, and I'm here to tell you that the rational basis test is a fraud. And if somebody says, oh, well, what about, rational basis with bite, or, this rational basis case was a winning case, that means it wasn't a rational basis case, okay? That means it was some other kind of case that may have purported to be a rational basis case, but it wasn't. So going back to Sandy Meadows, we challenged this occupational licensing law in court. The judge applied rational basis review, as he was certainly bound to do. And the thing about rational basis cases is they're not really a quest for the truth. Unlike a case involving even intermediate or strict scrutiny, which is a quest for the truth, the judge actually tries to determine what's really going on. Why is the government regulating this advertisement, or why is the government censoring this other kind of speech? Rational basis cases are not a genuine quest for the truth. In fact, the Supreme Court has specifically instructed judges in rational basis cases that they are not to be concerned with the government's true end. They are not to be concerned with the government's lack of evidence to support its factual assertions in court. And if necessary, judges are actually supposed to participate in the case and help the government justify its own law. In other words, judges are required to serve as advocates in rational basis cases for the government to help them win the case. And that's precisely what happened in this case. The judge upheld this law on various grounds, including the idea that the legislature might simply have been trying to protect the people of Louisiana from the physical dangers of unlicensed floristry. And these, of course, include what? Well, they include misplaced corsage pins, exploding bridal bouquets, so the bridal bouquets are held together with wire, floral wire, and judge hypothesized that maybe that can just come unsprung, and judge, not a judge, but a bride could trip over it. Then my favorite, infected dirt, and that's like How obvious is that, right? To this day, I still don't know what that dirt was supposed to be infected with. And I thought I had a really good counter-argument, which is they don't test for it. So even if there was such a thing as infected dirt, there should be a complete mismatch. But again, it's a rational basis case, so it's not really a quest for the truth. It's all a charade. And so the judge upheld the law, and it didn't work out so well for Sandy Meadows, unfortunately. I went down to prepare her for a deposition as the case was nearing its end. And I actually went to her apartment. She lived in this kind of, it wasn't exactly an old person's home, but it was a, sort of a assisted living facility, thank you. And when I got there, she didn't have a phone, so I would always have to sort of communicate. It was almost like I was, working with a secret agent or something. I'd leave microfilm under a bench or something to set up meetings with her. But I got to her apartment, and I went up to the second floor where she lived, and she was actually out in the common area. She was lying on a couch. And it was Baton Rouge in September. It was hot, it was humid, it was awful. And one of her neighbors was standing over fanning her with a piece of torn cardboard. And Sandy had just come out of a surgery. She had gallbladder surgery, so she had surgical staples from here to here. And I looked down at her, I said, what are you doing out here? And she said, well, they turned off my electricity. I have no air conditioning. And so this is the only place she could even be slightly comfortable. And it was as pathetic as you can imagine. So I put her in my rental car. I drove her over to a Piggly Wiggly grocery store. I wrote a check to get her power turned back on. And I took her to a Lincoln to Motor Inn just so she, checked her in so she could have at least one night of comfort. And I said, look, we're not going to do this deposition. I'm canceling it. We'll reschedule. Just get better, and I'll come back in a month or two. That was the last time I ever saw her alive. She died 2 months later alone, unemployed and in poverty, because the state of Louisiana said that she had to have a license to engage in a perfectly harmless occupation, and a federal judge treated her right to earn a living as if it was what I just described, totally unimportant and meaningless. We all know that's not true. We know that the ability to not have your house bulldozed so they can give the property to a wealthy property developer, that's not a non-fundamental right. The Supreme Court says it is, but that's not a non-fundamental right. We're Americans. The right to be secure in your home and not have it taken from you and just given to somebody else who might build a bigger home is a fundamental right. The Supreme Court doesn't think so, but it is, and we know it is. The right to earn a living in the occupation of your choice, not without any kind of regulation. I mean, I might not think it's a good idea to license lawyers, but that doesn't mean it's unconstitutional. I recognize that. That's policy. But licensing a harmless occupation like floral arranging, that's not policy. That's just protectionism. That is naked economic protectionism. It has no place in our system of government. And for the courts to pretend as if they are unable to see that that's what's going on, to turn a blind eye and participate with the government in this sham where they say, well, maybe you're just trying to protect people and their physical safety. I don't think it does any credit to the judiciary to go along with that. And Randy's, by the way, is exactly right. I have encountered this personally as a public interest lawyer, where we will challenge a law in court, like the Louisiana florist law. A judge will rubber stamp it, making no genuine effort to determine the true constitutionality of the law. And then we will go back, and the judge will always say something along these lines. Well, I'm not saying that this looks fair. I'm not saying it's just. I'm just saying it's not my job as a judge to strike it down. I have to apply rational basis review. That means I rubber stamp it. And what you need to
rationalize a basis?
Yeah, I call it the rationalize a basis test, which it is. Sometimes I call it Roosevelt basis review, just to remind my conservative friends whose water they're carrying, because that's when it was invented, and that's what it was invented for. But then you go back to the legislature after the judge rubber stamps the law, and here's what you'll hear, and that's where they send you. Oh, you got to go back to the legislature to get this fixed. And the legislature will say, oh, well, see, the court upheld it, so it must be okay. And Randy calls it double deference. I call it the death spiral of buck passing and finger pointing, where both branches just act as if it was the other one's job to get the Constitution right. Here's the thing that's important to remember. The legislature has the better of that argument. They have a responsibility to conform to the Constitution, but unless you believe in the Easter Bunny, don't think for a minute that's what's going on. You think that the U.S. Congress thought for a minute about the constitutionality of Obamacare? Preposterous.
You had to pass it first, didn't we?
That's right. Wouldn't even know if it's constitutional until you passed it. I think it is self-evident how dangerous it is to engage in this fantasy that the other branches reliably concern themselves with the constitutionality of the laws that they pass. They don't. So if we're going to have limited government, if we really want constitutionally limited government, there is only one way to achieve that, and it is not through reflexive judicial deference. It is with a judiciary that is fully engaged. That's why we use that term, judicial engagement, with a judiciary that is fully engaged in the process of judicial review, that does not turn a blind eye when the City of New London proposes to bulldoze Suzette Kilo's home by writing out of the Fifth Amendment the public use limitation, that does not turn a blind eye when the state of Louisiana puts a woman like Sandy Meadows out of a harmless occupation with a nakedly anti-competitive state licensing law, that does not turn a blind eye when the federal government usurps power year after year after year, making a mockery of the framers' plan for limited government. That's judicial abdication. That's not judicial restraint. That is judicial abdication, and we are now reaping the harvest of 7 or 8 decades of judicial abdication. The federal government between 1954 and 2002 passed 15,817 laws. The U.S. Supreme Court struck down 103 of those. That's 0.6%. Does anybody in this room think that Congress gets it right 99.4% of the time? I think that's rather a stretch. And so far from Arlen Specter, as he was on his way out of the Senate, thank goodness, back in 2010, complained that the U.S. Supreme Court was eating Congress's lunch with judicial activism. 0.6% strike down rate is eating their lunch? What would he think would be an appropriate strike down rate? 0? I mean, presumably, if there's going to be any judicial review at all, judges ought to be striking down laws at least sometimes. And ideally, the percentage of strike downs would equal the percentage of unconstitutional legislation passed. Now, we each have our own theory of the Constitution. I'm sure there would be reasonable disagreements within this room about what percentage of legislation is truly unconstitutional, but I hope no one would go to bat for the proposition that Congress is getting it right 99.4% of the time. I mean, talk about a blind squirrel finding a nut. Blind squirrel finding 99.4 nuts in a row. I mean, it's not plausible. So let me end with this. I use the term real judging and fake judging a lot, and I want to explain exactly what I mean by those terms. In my opinion, my experience, real judging is nothing more than this. Real judging is a genuine quest for the truth regarding the government's ends and its means by a neutral adjudicator on the basis of evidence. And we see that all the time. We see that in any heightened scrutiny case. Commercial speech cases, I've litigated plenty of those. Religious free exercise cases. Discrimination cases involving gender or race. The courts are perfectly comfortable in engaging in a genuine quest for the truth. Why, for example, did the city of Hialeah ban animal sacrifice? Was it genuinely about animal cruelty and sanitation, as the city claimed? Or was it about interfering with the Santeria religion, as was rather obviously the case? You can't decide that case without making that inquiry. Judges make that inquiry in some cases involving fundamental rights, or what I call meaningful rights, but mostly they refuse to make that inquiry. They just play along with whatever the government's doing. So real judging is a genuine quest for the truth by a neutral adjudicator on the basis of evidence. Fake judging is the opposite of that. Fake judging is the rational basis test. There's no genuine quest for the truth. The Supreme Court has specifically instructed judges not to ask what the government is really doing. The Supreme Court has also said that evidence is irrelevant in rational basis cases. The government may base its positions on rational speculation. That's not litigation. I've litigated for 20 years, both in constitutional cases and non-constitutional cases. I know what real litigation is. In real litigation, parties do not get to make factual assertions for which they have no evidence, or at least the court does not accept, outside of the rational basis test, courts do not accept factual assertions for which a party has no evidence, but they certainly do in rational basis cases. Why? Because the whole point of a rational basis case is simply to rubber stamp whatever the government is doing. And I've told you already, I don't believe that the judge is a neutral adjudicator in rational basis cases. Why? Because the judge has been charged by the Supreme Court with helping the government win. I'm not saying they do it all the time, but I am saying that when I go in and I do a rational basis case and I represent a plaintiff, that plaintiff knows very well, and I know very well, that that judge has been charged with helping the government win if necessary. And that's not an appropriate position for any litigant to be in. And by the way, outside of the rational basis litigation, in every other setting, a plaintiff has a right to a truly neutral judge. So if I went in and represented somebody in a breach of contract case against the government, the judge certainly would not pull me up to the bench and say, I just want to make sure you understand I'm going to help the government think up justifications to your defense, your breach of contract, right? I mean, that would be ridiculous. In every single context except rational basis litigation, that would be ridiculous. And here's what I want to leave you with. Rational basis review is the default setting in constitutional cases today. That's the standard that judges have been instructed by the Supreme Court to apply. And it's not a standard. It's not a test. It's a constitutional shell game in which liberty is the P that disappears at the end. We've had 75 years of it. Does anybody in this room think that America can take another 75? I don't. Thank you. And I would love to, thank you very much. That was very gracious of you. I know I had some hard things to say there, but I'd love to hear your questions if anybody has any questions. Is that all right, Matt?
Yeah, let me ask you.
Yeah.
Did the court just took it on itself to create this distinction between fundamental and non-fundamental rights? I mean,
Yep.
And do you think that the Ninth Amendment could be a remedy to that? Because many people argue that, as you do, that the Ninth Amendment codifies or at least expresses the intent to reaffirm the natural rights that we possess that we never would relinquish to government.
I do. I appreciate the question. So for those who don't know, let me frame it this way. Judge Robert Bork he's deceased recently, but he was probably one of the leading intellectual influences on modern conservatism, and particularly he was a very strong proponent of the kind of judicial restraint that I think Judge Wilkinson advocates. A very interesting thing that I think is incumbent on all of us to really think deeply about is the fact that in order to basically advance this doctrine of what I again call reflexive restraint, call it what you will, judicial restraint, Judge Bork had to do something very strange for a self-professed textualist and originalist, and that is that he characterized both the Ninth Amendment and the 14th Amendment's Privileges or Immunities Clause as ink blots. He literally refused to give any meaning whatsoever to specific, explicit provisions of the U.S. Constitution. Nobody who calls himself a textualist should ever characterize anything in the Constitution as an ink blot, and yet Judge Bork did it not once but twice, the Ninth Amendment and the Privileges or Immunities Clause of the 14th Amendment. It seems to me rather obvious that once you have done that, that is about as bright a red flag as I can think of that you are off on the wrong tangent. So the Ninth Amendment reads as follows: the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. I just can't think, how much clearer could they have been? And we know from history that there was a huge debate about whether we should even have a Bill of Rights, because everybody understood that the moment you put pen to paper, you open the door to the argument that unfortunately gets made today that anything not listed doesn't count. And you should read Randy Barnett's book if you're really interested in the history by there. Randy Barnett has a book called Restoring the Lost Constitution, in which he describes the debates over the Bill of Rights. And people were literally saying things. One congressman, they were arguing about whether to explicitly acknowledge the right of assembly, which is in the First Amendment. And one congressman got up and said, to put a right of assembly in the Bill of Rights would be to trivialize the Constitution. Of course that's a right. And to even mention something so obvious would be to trivialize the document. And they got into things like whether there should be an explicitly acknowledged constitutional right to go hunting, or to go fishing, or to wear a hat if you want to, or get up or go to bed when you want to. And that's the dilemma. That's the problem. Every single day, every one of us does things that we count on the ability to be able to do, even though it's not articulated in the Constitution. I wake up, I hold my son in the morning. I got a 5-month-old baby at home. And you better believe that I'm making plans for the way his life's going to be. There was actually a Supreme Court case about whether the government can step in and force you to send your children to public schools if you don't want to. That was in 23, Pierce v. Society of Sisters. Oregon passed a law criminalizing private schools and making it illegal to send your child to a private school. The Supreme Court actually, to its credit, managed to get that one right. They struck down that law. But there's nothing in the text of the Constitution that protects your right to have a child or to raise that child or to direct the upbringing of your child. But the Supreme Court found that that is a constitutional right. And you can do that in one of two ways. If you're talking about a federal law, then you can come at that two ways. One is the federal government has no legitimate power over education, so that would just be where we would start. Unfortunately not today, because the Supreme Court has gotten that wrong. But you could go to the Ninth Amendment and say, look, just because there's nothing in the Constitution specifically about my right to raise my own child doesn't answer the question. Because after all, what does the Ninth Amendment mean, if not that there are other rights? And remember the text, that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage rights not mentioned in the Constitution. I can't think of a more effective way to disparage a right than to assign as its sole protector the fraudulent rational basis test. That is the very definition of disparaging a right. The other thing I would say is this: if you're talking about a state law, and I know I'm opening a big can of worms here, but I personally believe that the Privileges or Immunities Clause of the 14th Amendment has the same effect at the state level that the 9th Amendment does at the federal level. The Privileges or Immunities Clause was designed to protect a rather broad range of individual liberties. We may have some disagreement at the margin over what those are, but we know what it means to be an American. We know what it means to live in the land of the free. We know that in our country, the government doesn't get to show up at your doorstep and take your child away for political indoctrination, even though that's not specifically mentioned. I could go on, but that's the point. And so I am a big believer in unenumerated rights. I absolutely recognize the door that that opens. I understand that it is intellectually difficult to identify what those rights are. But I also believe that America would not truly be America if the government only had to respect the very small handful of rights that are specifically written in the text of the Constitution. We would be a much different country. So, does that answer the question? Yeah. All right, thank you. That was good setup. Does anybody else have any questions? Yes, sir, in the back, yeah.
The Commerce Clause in this Affordable Care Act and this right of taxation, it was argued all through the lower courts that this was passed pursuant to the Commerce Clause.
Yep.
All of a sudden, the abandonment of this tax argument,
Yep.
all of a sudden, in what limited experience I got in law is if you don't raise the issue during the proceeding, you don't have a right to have a court. How in the hell did you get it?
They did raise it. They argued it.
Very brief, though, wasn't
Yeah, it was raised and preserved, but it wasn't emphasized.
But the Commerce Clause was restricted in this Affordable Care Act. You read it carefully. I read it as if it was a restriction on the ability of Congress to railroad everything through the Commerce Clause, and in a way it has a restriction on legislature.
That is one way to read it. I would tend to agree more with Randy Barnett, who says that what really happened was the government proposed to expand the interstate commerce power even beyond what had been approved up until that point by basically conjuring a power on the part of the federal government to go after people who aren't doing anything economic. I mean, I sat around all day today not buying a health insurance policy on an exchange. I also sat around all day not buying an electric car, which is something I'm sure President Obama would love for me to do. But so up until that point, the government had never been, or the Supreme Court had never, and I believe the Congress had never asserted the power to force somebody into commerce, to make them go buy a product, in this case government-approved health insurance, and then regulate them as they go about that activity. So I think that I would agree with Professor Barnett that what the Supreme Court did was not so much trim any existing Commerce Clause doctrine, but instead refused to go along with a proposed expansion of it. But reasonable people could differ on that point. Yeah. Is there any other questions? Feel free. Yeah, please. Yeah.
I've done some work a few years ago, and I want to know if you had an update on the arrest by police officers of the public and members of the press filming them in public places while they did their duty. Some of the circuits have ruled that...
Commission absolutely.
Yeah.
I have very strong feelings on this. So those who don't know, one of the burning issues in constitutional law, or I think it's a burning issue because the Supreme Court hasn't weighed in on it yet, is whether there is a constitutional right to record the actions of public officials, including particularly police officers in public. Some states actually criminalize it, only a couple. Illinois is one. Illinois actually calls it eavesdropping. Even though literally the state, when this was litigated, acknowledged that it's not really eavesdropping. It's just I'm standing here watching police arrest somebody. It starts to look weird to me. I pull out my cell phone, and at this point, no kidding, as soon as I press the record button, I have committed a felony in Illinois. And if it's a police officer, it's a Class 1 felony, punishable by up to 15 years in jail. Not when I went and hid my phone where no one could see it and they thought they were having a private conversation. Literally 6 feet away from me, somebody's being arrested. I hit the record button on my phone. I'm a felon. That's really sobering. I'll just tell you what the status of this argument is. On the one hand, you have strong proponents of judicial restraint, like Judge Posner on the Seventh Circuit, and on the other, you have what I would call proponents of judicial engagement. This case actually came to a head in the Seventh Circuit 2 years ago in a case called, believe it or not, ACLU v. Alvarez. The ACLU actually did something useful. ACL, this was the abuse of this power was so egregious in Illinois that the ACLU finally put together a test case and went to try to get a preliminary injunction because they didn't want their guinea pigs to go to jail. And they said, look, there's a constitutional right to record police officers in public. A couple of circuits have weighed in, and we want the Seventh Circuit to go ahead and say that there's a constitutional right to this. The district court actually dismissed the case on the premise that this is such an outlandish argument, that there's a constitutional right to record police officers that you don't even have standing to bring a case. They appealed that to the Seventh Circuit, and it produced the most interesting decision that I commend you. It is in the book, but you can also just go online and find it, ACLU v. Alvarez. And here's what's so interesting about it. It was a absolute textbook example of judicial engagement on the one hand and judicial abdication, as I define it, on the other. Judge Diane Sykes, who I'm a huge fan of, she's a former Wisconsin Supreme Court justice. I mean, I would say, a conservative in my mold, someone who really takes seriously the Constitution. She wrote for a 2-judge majority, declaring the law unconstitutional, or at least enjoining it, handing down a preliminary injunction. They didn't make a final decision yet. And she went through and did a very well-reasoned opinion where she essentially said, look, the Supreme Court has already held, that the right, for example, to show a movie is constitutionally protected. So surely the right to create that movie is constitutionally protected. And by the way, accurately recording the public activities of public officials is right at the heart of the First Amendment. The First Amendment is, first and foremost, about political accountability, right? That's why we have a right of free expression. That's why we have a right of assembly. It's why we have a right to petition. And so this right clearly lays at the very heart of the First Amendment. And the mere fact that the Supreme Court hasn't weighed in yet doesn't give judges a free pass to just say, well, it's none of my business. Judge Posner disagreed. Judge Richard Posner wrote a decision, and I commend it to your attention. I criticize it at some length in the book. Judge Posner's approach was essentially in 3 parts. First, he said, judges should strike down laws only with great reluctance, and it should be a solemn, and basically sorrowful judicial duty. Well, why should that be? And only done rarely. Well, why should that be? I don't know how much unconstitutional legislation comes down the pike. Is he making an empirical statement that there's only, you'll only ever have occasion to do it once in a while because legislatures are really getting it right? Or is he saying no matter how much unconstitutional legislation comes down the pike, we should only strike down laws? Rarely. And then he reasons, and this is the part that I think was as opposite of judicial engagement as it gets. Instead of confronting the law for what's really going on, I assume everybody in the room knows what's really going on with this law. The state of Illinois does not want accurate recordings made of its state and local officials because this will cause problems. That's what's really going on with this law, but instead, Judge Posner, doing what judges typically do in rational basis cases, which he never actually came out and said it was a rational basis case, but he pretty much reasoned in that way. He said, well, maybe this law is about protecting the delicate sensibilities of shy police officers who, when they see a camera pointed at them, will freeze. My wife is from Chicago. Judge Posner sits in Chicago. The police in Chicago do not exactly have a reputation as shrinking violets who become flustered in the presence of reporters or camera-wielding citizens. But that was the premise on which Judge Posner said that basically the state of Illinois has carte blanche to put people in jail for recording, again, the public activities of public officials and make it a Class 1 felony punishable by 15 years in jail. That is the face of judicial abdication. And many conservatives would just call that good old-fashioned restraint. If that's restraint, I don't want any part of it. Yeah.
In the context of what you were just talking about, I was reading that possibly Alito and maybe some of the other folks had some of their private conversations recorded by the black box in the sky.
Wow.
And of course, I'm crazy to spray roast. Everybody knows that.
You mean the NSA?
Yes, sir.
Okay.
And the thought then that maybe Robert's flipped for some reason. I don't know exactly what. Is it possible, and this is weird at the science, that perhaps there was some kind of a blackmail involved in him going from.
I generally apply Occam's razor to these kinds of things. I don't think we need to.
There was.
Well, listen, no, I don't think we have to hypothesize a conspiracy theory. Go back and look at Chief Justice Roberts' confirmation testimony. He emphasized over and over again how humble and modest he was. That's code for saying yes to government. He was basically asked by the Senate Judiciary Committee, look, if we confirm you as Chief Justice, will you be a doormat for us? Will you lay down for us and just pretty much say yes to everything we do? And what he was doing throughout the hearing was communicating to them in thinly veiled code that, yes, I'm your boy. Put me on the Supreme Court and I'm a yes man. That's what humility means when you say it in that context. And when he said his leading characteristic as a judge was to be modest. I don't have any problem with modest judges. What I have a problem with is when modesty is code for, look, you send any stinking piece of up to, my court, and I'll do my best to try to figure out a way that it's constitutional, no matter whether you were careful or not careful when you drafted it. Again, that's what we've had 75 years of. And look, I have the utmost respect for the Chief Justice. He is a brilliant man, and I think he's going to be among the better Chief Justices. But obviously, this decision was a black mark. But I have to tell you, I really think he was just delivering on what he promised. They said, are you going to be modest and humble? He said, yes, I'm going to be modest and humble. And when Obamacare came up to the Supreme Court, if you want to know what humility and modesty look like in application, you read his opinion. He considers that a modest opinion. Why? Because he was restrained.
Or did he actually think that there'd been an electoral solution to this problem that was presented? And somehow...
I can't get inside his head. What I can tell you is, from watching every confirmation hearing for the past 15 years, and I went back and looked at them all and I read them all, the ritual is always the same. The ritual is always, senators say to nominee, we've got this terribly activist judiciary that's always saying no to us. If we confirm you to the Supreme Court, what are you going to do about this terrible activist judiciary? To which there can only be one response if you want to be confirmed, and the response is, I'll be a doormat. I mean, I may care about one or two rights, you might run into something I care about like free speech or religion or something like that, but outside of the couple of areas that I care about, take my word for it, I'm really, really into restraint, like really into restraint. And that sounds fine. That sounds fine in the abstract. None of us would have a problem with a judge sitting there saying, no, I'm very modest, I'm restrained, and I'm humble. Great, those are wonderful qualities to have. But when that is code for abdication, when that is code for, I don't see anything wrong with the last 75 years of federalism jurisprudence. As I said before, I don't think we've got another 75 years of that kind of jurisprudence. At least I don't think we will still be a recognizably rule of law country if we continue down that path for another 75 years. But that's the path that restraint, not the good kind of restraint, that's the path that kind of code word restraint, reflexive restraint leads to.
This is the follow-up.
Yeah.
And I've
Yeah.
had this problem issue before coming for me. Where is the judge's duty? To his oath to the Constitution or to stare decisis?
Well, listen.
And I think it's to the Constitution.
I've never worn a robe, and I don't expect to wear a robe anymore. I'm not after giving these kinds of talks. But I started the talk by saying that I absolutely understand that judges on lower courts are constrained. I do not want judicial anarchy. I worked for a district court judge. I'm not proposing judicial anarchy where judges just say, well, you know what, you've had your say, Supreme Court, but this is what I think.
There's rare occasions.
Well, look, there are many cases that could go either way, even under existing doctrine. You are not obligated. I mean, look, the Obamacare decision, I think, is a good example of that. Chief Justice Roberts could just as well have written that opinion the other way, and many people think that he was on the other side up until shortly before the decision issued. So I think the truth that we all have to come to grips with is many constitutional cases are close cases, and a lot of where you end up matters of what your basic operating principle is. And if your basic operating principle is, I have an obligation to say yes to the government if there's any way I can think of to do it, you're going to say yes a lot. Yeah, go ahead.
So you're looking at the courts as being more of a legislative branch?
Nope. I'm looking at courts as more of a rubber stamp. I think many judges have exchanged their gavels for rubber stamps.
So our separation of powers up there is diminished?
Yep. Well, listen, I think the main project of the U.S. Senate over the last 30 years has been to cultivate a more docile judiciary, a more docile Supreme Court that will be more inclined to say yes to whatever the federal government is doing. And all I would do is I would just sort of, as Thomas Jefferson said, I would submit to a candid world whether you think that's a fair description or not, whether you think that the federal government typically runs into a lot of trouble with the U.S. Supreme Court when it comes up with some new thing to regulate. I think the numbers speak for themselves. I think the Supreme Court has essentially said to the Congress, look, don't worry about us. You know, it's up to you. If you think it's constitutional, then you know, we're not going to second guess you. Again, outside of a very small handful of areas like the First Amendment and a handful of criminal procedural protections that they're still, you know, hewing to. But yeah, by and large, I mean, put it this way: tax policy, anything economic, property rights, federalism, you name anything you really care about, except maybe for speech, guns, and religion, and the Supreme Court has just, you know, basically thrown open the doors to the other branches. I think that's where we are.
Hobby Lobby will go the same way as Obama?
No, I don't. You know, we've been hearing some reports. I mean, so there's something that's kind of interesting about Hobby Lobby, and that is that it involves not really, there are constitutional arguments in the case, but mainly it's a statutory case. Mainly the case is about whether the Religious Freedom Restoration Act that Congress passed to essentially resurrect a more stringent standard of review for religious exercise claims applies to the plaintiffs in this case, who are essentially people who claim to be, you know, the owners of a company who have religious feelings about not providing certain kinds of birth control. And from what I heard of the argument today, it sounds like the government is got real problems. They didn't have very good responses for some of the questions that they were asked, and even from what I hear, even Stephen Breyer, of all people, was skeptical. So I think, and let me just really quick add one thing. There are, I think, by last count, several dozen cases going through the system right now challenging various discrete aspects of Obamacare. There's no one case that's a knockout punch. That we already know we lost that one. But I actually think that there's enough cases going on right now that if the plaintiffs in those cases win, you know, even a third or a half of them, I actually think there's a pretty decent chance that Obamacare will be rendered, well, I was going to say even more dysfunctional. I mean, it's pretty dysfunctional right now, but essentially to a point where everybody has to agree that it either has to be rewritten or repealed, because it's like an engine that has seized up. I think it's kind of on the verge of doing that right now, and it probably wouldn't take more than, you know, a handful of these cases that knock out small, discrete parts of it. So I think there's a possibility of some good news, though. This particular case, the important thing to remember, though, is it's basically a statutory case. This is an example of a freedom that Congress cared enough about, you know, to resurrect some measure of freedom with the Religious Freedom Restoration Act. So I don't know.
It's already been struck down, though, as applied to the states is unconstitutional, though, right?
What's that?
Part of the Religious Freedom Restoration Act has been struck down, at least in federalism grounds. It doesn't apply or can't apply to state and local governments. Is that right?
Yeah, my understanding is that essentially
the federal government. Is that right?
It only applies to laws that are passed by the federal government, because the Supreme Court held that the 14th Amendment does not empower the federal government to essentially try to provide that kind of prospective relief at the state level. Interestingly complex doctrinal question, Matt. Thank you. Is that anybody else? Yeah.
The Patriot Act secret courts.
Yeah.
What review, if any, is there for these judges that say that in a secret proceeding?
The FISA courts?
Yes.
Okay.
You go to King George II.
But that has really scared me.
Yeah.
As to what review these secret courts have.
Yeah.
if any.
Well, so my judge, Judge Lamberth, was the chief judge of the FISA court for I think about 6 months while I clerked for him. I don't know a whole lot about it, but I will say this. Unfortunately, many of the decisions that the FISA court makes, there's no one who has standing to appeal those decisions. They're ex parte. So literally, well, they're often classified, right?
I mean, you don't know.
Right.
There's no really precedent.
But some of them can be reviewed. And so, for example, Freedom of Information Act challenges where somebody says, we want to see this opinion. The D.C. Circuit actually did order some FISA decisions to be published. I will say I want to throw this out for my judge, Judge Lamberth. Judge Lamberth strongly resisted the idea that FISA is necessarily a rubber stamp. It certainly does approve most of the warrant applications that come in front of it, but Judge Lamberth has a very well-known reputation as being scrupulous about, particularly when government officials come in front of him, engaged. He actually, believe it or not, banned a particular FBI agent from ever again testifying before the FISA court, because this was the guy they would bring in, with an affidavit who would sort of just have the boilerplate in there and he would say blah, blah, blah. And it turned out that in one or more proceedings, it became clear to the judge that this guy did not have personal knowledge of the things he was going to bat for, and that in fact, in some cases, the things he was going to bat for were wrong, and he banned this FBI agent from ever testifying in front of the FISA court again. So I share your concern about the court. I think there is something very, very concerning. And you're right, it harkens back to some very ugly periods in pre-American history where you have, basically it's a star chamber. But we also have to recognize, I assume everybody in this room recognizes that in this day and age, some things have to get done that it is unwise and counterproductive for everybody to know about. Where the line should be drawn is something I think we are still trying to work out. My sense is that I personally feel like we are probably being a little bit overly deferential towards security officials. Some of whom I know. My best friend's a very high-ranking lawyer for the CIA, so I have some insight into this. Not operational insight, but I have some insight into how lawyers in that community think. And I will say that they do try very seriously to take very seriously the laws that apply, but those laws are really, really stretchy. Yeah.
Is there a difference between recording a policeman on the street and recording in our courtrooms?
And recording in courtrooms?
Yeah,
That's an interesting point.
recording in courtrooms.
I have not actually. Yep. So I would say that the answer must certainly be yes, and I don't know how I would support that other than to say that the Constitution does make clear that court proceedings are generally required to be open to the public, so you can't bar people from coming in there. Other than the Supreme Court, I've never been in a court that forbade people from taking notes, so that's something else you can do. Whether you could make an argument that that there's either a constitution that there's a constitutional right to record what's going on in that courtroom is a really interesting question. I have to confess that I've never thought of.
I'm just thinking about it.
It'd be rough sledding in the U.S. Supreme Court, I think. Yeah.
I think one way to get around that is that the way our courtroom is structured, they can actually film through glass and get a complete video.
Okay.
And then the reporters are allowed to come in and take notes
Okay.
Without restraint in the courtroom. They can't actually film inside the courtroom, so that's maybe one way.
It is a verbatim recording, but I should know where, a lot of judges have kind of gone overboard that you can't tweet and you can't do all this kind of stuff.
Yeah.
I should know where to do all of that because it's the 21st century of the quill pen and parchment.
Yeah.
It really is. I mean, you're trying to keep that from the jury, but you've already ordered the jury to be sequestered.
I'll tell you, one thing that's just kind of a pet peeve of mine is the Eastern District of Virginia, which is the federal court nearest to where I practice, is they don't allow you to bring cell phones into the courthouse at all. No cell phones past the front door, and they don't provide any place to put them. So there's actually a little diner across the street that does a land office business. This guy's got little cubicles in his diner. You have to go across the street to a diner and check in your phone. So, but I mean, I'm certainly not saying I think it rises to the level of constitutional challenge, but it's rather impolite, I think. Maybe I should rethink that.
Business makes no difference.
Right. We done?
We tell people they can't tweet in my courtroom. I think I'm violating the Constitution.
And actually,
I my order. Why would you ban for tweeting? You sound like a Democrat.
I don't allow the use of them.
it does occur to me, I should say it does occur to me that my experience at least is that generally a party has a right to request that a hearing be transcribed. So that strikes me as getting most of the way there, so, and I think.
If you have an official court reporter,
Just
you
a
get
bullet.
someone else, you get the question of what's correct, and that can be a real problem.
What about this
right,
issue?
right.
You can take notes.
Right.
So why can't you take notes then on your computer, and then why can't you tweet?
Can you have two different rules?
The
One for
argument
media, one for
is that
labor?
you don't want to poison the jury.
Right.
But you've already protected the jury from being poisoned by their instructions and keeping them separate.
Right.
So why then are you 60 years ago, you used to have a runner from the newspaper come over and get the physical notes from the reporter so it's the same thing. It's the equipment.
I think the challenge, these are all intriguing arguments. I'm just not sure what forum you would advance them in because it's ultimately.
I'm saying I've already taken the bull by the horn, but it's the high-handedness of a lot of people that we're not going to let you bring the cell phone in there. lots of lawyers run their businesses from the cell phone.
Oh, I'm aware.
Ban them from the building, they're losing money.
Yeah.
And I think a lot of judges need to think about that.
I mean, you absolutely got a right to maintain order, and if noise is going on.
No, and mine says that you got to maintain quiet in the courtroom.
I'll tell you, I mean, I don't know if we're doing a free-for-all here, but I'll tell you, I had a very disconcerting experience in what happened to be a rational basis economic liberty case. I went in, I'm from Texas, this case happened to be in Texas, I guess it doesn't matter that it was, state court in Texas, and basically it became pretty clear to me once the judge understood that it was, you know, a rational basis economic liberty case. We were there on a, what they call a temporary injunction hearing. At one point I could see that the judge was just very, I was, you know, putting on witnesses and we're doing a whole hearing, and I could see that he was very involved in his computer, and I was thinking, well, maybe, I was thinking the court reporter might be generating a real-time transcript, and he just takes in information better visually, and so he's reading the transcript as it comes up. So during a break, I asked her, I said, you know, are you giving the judge a transcript as it comes up? And she said, no, he's just surfing the internet. It was so disconcerting. Like, Your Honor, please, can we just pretend?
Depending on the judge, that might be better.
Yeah, I mean, he was a nice guy, but he was obviously didn't feel like any of the information. Yeah, well, no, and, you know, so. Anyway, well, listen, thank you guys very much. I really appreciate the opportunity. Thank you.